Ang nag-mute ng ano nila, tayo, di ba?
Naka-mute naman kayo pareho. Freeze.
Parang habang inaayos mo yung screen, hindi na yung mga.
Yun nga, yun. Yan, nakapause.
Pero dapat naka-split screen ko.
Hindi ko po ma-explore kung paano split screen.
Yung dun sa PowerPoint mo, dapat naka-split screen.
PowerPoint.
Okay. Good afternoon, everyone. Are we all set? Okay. Again, good afternoon. Welcome to the HIVE. The HIVE is the NTFP-EP e-learning platform. This is our second installment of our first webinar series entitled Community Intellectual Property Rights. Why the name HIVE? Well, HIVE was inspired by the beehive, where it's the place where bees exchange information and where their knowledge sharing system takes place. Well, we will strive to be that dynamic platform like the bees, hence the webinar. So I'm Edna Magigad, Regional Policy and Governance Advisor of NTFP. And looking at the screen and around me right now, we are around 30 people who are also excited to learn about TK and TCE, or traditional knowledge and traditional cultural expression. Before we go into the substantive part of the webinar, I will remind you of our webinar ground rules. So your microphones are all muted throughout the session. So please maximize the chat box, or you can click the raise your hand button if you have any question, and we will address this orally or send you a text reply within the Zoom platform. The presentation will last around 1 to 1.5 hours, and the 30 minutes are spread across the session, where we will have a break to have a deep dive into some key topics that I think are of most important to those attending the webinar at the moment. So for centuries, indigenous peoples and local communities around the world have learned, used, and passed traditional knowledge for many purposes. Of course, to know this from food, medicines, good planting, harvesting, weaving, to good forest management practices. The 3 webinars are designed in such a way that we will have an introduction into the United Nations WIPO, or the World Intellectual Property Organization. Under WIPO, we learn, or during our first webinar, the different intellectual property tools available for the protection of community intellectual property rights. We will have a short review of that before we begin into the second webinar. Okay. So we also learn about the Madrid system of protection during our first webinar. For our second webinar, we will now take a deep dive into what are actually traditional knowledge associated with a lot of the practices that brings into products, etc., that can actually be protected under the intellectual property rights. We also would learn about the traditional cultural expression, and of course, at least at the end of the webinar, have a working knowledge of the difference between the two and how we can effectively protect these two expressions. So, for the second webinar, we would like to familiarize ourselves again with these IP tools and identify existing protection as well as limitations that can be given to TK and TCE. Again, I'm happy to welcome our guest expert, Attorney Jean Corpus, a lawyer from the Kankanay Guruk tribe of Mountain Province in the Philippines. She's really an expert, being a graduate of the Indigenous Intellectual Property Fellowship of the World Intellectual Property Office, WIPO, in 2012. And since then, she has been very active in a lot of international and national discussion to promote the protection of TK and TCE using intellectual property tools. So, Jean, welcome.
Thank you. Okay. Thank you, Edna. I'm very pleased to be here again at this second installment of our webinar series. As Edna said, we will be going through several topics, and we're trying to look at exactly how traditional knowledge and traditional cultural expressions can be protected. I will be sharing with you certain approaches that have been used and found effective in different countries. So I will start now to share. Okay, oops. I will now share my screen with you. Okay, so Edna has already walked us through the objectives of the session. So now this is going to be the flow of our session for today. And I hope you can bear with me. I'll try to keep it short. And well, you can always raise your hand if you feel that I am talking too fast or if I am talking too technically. We want this to be simple and easily understood. Okay, so the outline of the session is as follows. First, we review the tools that we learned about at the first webinar. I noticed from the list of participants that not all of you were part of the first webinar. So I hope this part can be very useful for you. Then we look at the definition of traditional knowledge and traditional cultural expressions. And I hope you are ready also to share with the group examples of TK and TCEs from your communities. Then we look at the intellectual property system and look at whether the way it is currently structured is appropriate to protect traditional knowledge and TCEs. And the last part, if it's not appropriate for protection of TK, should it indeed be modified in order to protect TK? So then we look at the reasons why TK should be protected. And then we looked at this word protection. What does it mean? There are many different meanings in the international and national system of the word protection. Okay, so let's start. This now is the review. So we remember that intellectual property rights is a balance of two different interests, okay? So there's this arrow down here and an arrow up there, and it's meant to balance the moral and economic rights of the creators of intellectual creations, inventions, and the like, as well as access by the public to the fruits of the creativity. Of course, when you create something, you want people to be able to use it. If it's an invention, you want people to be able to buy it so that the inventor can earn money, benefit from the invention. Okay, so it's a balance of two different interests. The tools that we went through at the first webinar were industrial property. Broadly speaking, these are the categories. And under industrial property, we already looked at patents, we looked at trademarks, we looked at industrial designs, we looked at geographical indications, and we sort of had a quick look at how these are relevant for TK and TCEs. Then on the other side, the other category is copyright and related rights, and this is more in relation with creations, creativity, okay? So we have here copyright for literary and artistic musical works, as well as the right of those who act or produce the music, those who sing, and those who distribute. And of course, we saw that the limitations of this system is that there is only a time limit to the protection given by the system. There's also a limit as to the geographical scope where it is protected. And it is an exclusive right of the creator that the creator, of course, can sell or license or allow others to use for a fee, okay? So don't worry. It's a bit abstract for now, but we will give you examples later, okay? So broadly speaking, what is intellectual property for? There are two broad categories, okay? One is to provide recognition and commercial reward from creations and inventions. Those are the patents and industrial designs and copyright. And the other is it's a marketing tool. It's to help the customers differentiate between different products. And if they see this particular mark, then they know that one product is superior to the other, okay? So those are trademarks and geographical indications, okay? So enough of the theoretical definitions. Now we go to the practical or examples, okay? So I hope that those who attended the first webinar can answer this. But first, I will flash some pictures, and I want you to tell me what type of intellectual property tool was used in these instances. Well, this should be very familiar to the NTFP members in the audience. Okay, so 5. And for the moment, I would like to invite Edna to perhaps provide short explanations so that the participants can think about what type of intellectual property tool was used here. Edna?
Oh, so these are distinctive marks. Okay, sorry. So we see here distinctive marks of the work of NTFP that includes, these are distinctive mark for products, for practices, for an indigenous-led network, as well as for an office, a craft center. So these are marks that distinguish the various work of NTFP network with others. So that's my simple way of explanation without actually saying what it is. I can describe, for example, when you say good hinabi practice, if you have a mark like that, it's an evidence that your particular product has gone to certain quality standards of these particular practices. Usually, this good hinabi practice was developed by NTFP as a technical assistant to indigenous people's community. And if you pass this, it means that certain indicators and quality standards for products, particularly for hinabi, which means weaving, were actually complied with. Okay, for the NTFP, the logo is our name as a trademark, as an organization. It means non-timber forest products. So it distinctly separates us uniquely from other words like ordinary minor products, which is used also the legal name of NTFP in some documents. It's also non-wood products. So we wanted to highlight non-timber forest products, not being ordinary. And then, of course, the rest are actually self-explanatory. Let's go to the quiz, right? It's actually a poll to know what is the the intellectual property tool used here. So, Jean?
Okay, so there is this poll. You have around 15 seconds to fill it up. Excellent. I can see that some people are very familiar with these pictures. Okay, what about the others? Okay, good. Around half have already voted. What about the others? Okay. Last 10 seconds. Okay, so that's it for the poll. I think most people know what was flashed. So you are right. 13 of you said trademark, and this is exactly it. It's a trademark. Some answered geographical indication. Perhaps that could be considered because collective marks or collective trademarks are also a type of geographical indication protection. Okay, so if you're a bit confused and you weren't at the first webinar, I will provide a short explanation later. Okay, so let's proceed for now. Next, what IP tool was used here? So this is the second poll. Okay, we already flashed the, okay, you can think about it. You can start thinking about it and answering using the poll. Okay, so you can see here, looks like a blanket or a towel or a carpet that has two lizards. Okay, and then beside it, there is another similar figure. And if you can take a guess at what the original is and what the copy is, I would like to say that the left one, the less elaborate one, is actually the original artwork by an Aboriginal artist in Australia. Okay, this is similar to some of our weavers here in the Philippines. This is generated from the dreams of that Aboriginal person, and it has some spiritual meaning to that Aboriginal group. Okay, and to the right is a carpet that was claimed by a carpet maker, and she had it produced outside of the country, I think in Indonesia, and then imported it into Australia in order to sell it. Okay, now the original creator of the work challenged the copying that was done by the carpet maker. So what tool was used in this instance? What tool would enable an artist to claim that someone else is unlawfully copying his or her work? Okay. This is not the correct poll. Okay. The questions, the answers are supposed to be the different IP tools. So let's withdraw this poll for now. Okay. There you go. Okay, there it is. This is the correct one now. Excellent. Many people know what these things are. Okay. Half have voted. Last 10 seconds. Let's give a chance to the others. Ah, sorry. Okay, let's give a chance to the others who haven't voted yet. 3, 2, 1. Okay, let's end the poll now. 8, around half answered copyright. And that is the correct answer. It's not a patent because it's not an invention. It's not, it doesn't fulfill the criteria for an invention. It's not really a geographical indication, or although this can be one of the tools used to protect creations by indigenous artists. But in this instance, it's not a geographical indication. An industrial design also can be used to protect this, but in this instance, it wasn't what was used. And definitely not a trade secret, okay? So let's go to the next. So this is a copyright, okay? The next slide shows, again, 2 pictures. To the left, okay, we can relaunch the poll again so that they can choose what IP tool, okay? So this is a picture of what? What do you think this is a picture of? It's strange, huh? These are potatoes, but not really potatoes that I have ever seen in my life. The only potatoes that I know here from the Philippines are the violet ones, and I think there are orange and there are white or yellowish potatoes. But here, many different varieties of potatoes. And then you see to the right, this is a something that is pasted onto the potatoes, okay, to assure others that it is of a very high quality and that it's produced in an area where, which is the center of diversity or center of origin of these potatoes. Okay, can we launch the poll again so that we can see how many people know what this IP tool? We have to relaunch the earlier poll. Yeah, perfect. Okay, I'll give you 15 seconds now because this looks a little bit easy. Okay, okay. Let's end the poll now. And most of the people, almost all, save for 3, said geographical indication. And geographical indication is usually used for agricultural products, no? And it's related to the particular properties of the soil and the climate in a particular area, which produces really good tasting agricultural products, no? In this instance, it's actually a collective trademark, but that is probably because there was no law in this area that protects geographical indications. Okay, so you're correct, it's a GI, although it takes the form of a collective trademark. Okay, shall we go to the next? The next is, okay. There are words there, it shows, so it should be easy to guess. Okay, it certifies the quality of a product. Okay, and here this is something that is used by the Maori in New Zealand to certify that it's produced by Maori artists. So it cannot be produced by persons who are not Maori. Part of the what the mark certifies is that most or all of the proceeds from the sale goes to the indigenous artist. Okay, so what IP tool is used here? Let's start the poll and let's give 15 seconds for the participants to answer. Okay, let's go. Okay, let's end the poll. Yes? Was it confusing? It seems from the answers that this was a little bit confusing. It's called a certification mark, which is a type of trademark. And it's similar to what Edna said earlier about the good hinabi practices. It certifies that something is produced according to standards, well, specified in a code of practice. And it also certifies as to the origin of the product and as to the person who benefits from the product. Okay? Can you see yourself using this to protect your TK-based products? So this is one thing that we should be thinking about as we go through the examples. Okay? So the next one, I think this is the second to the last. What IP tool was used here? Okay? To the right, you can see a picture of a hat. And to the eternal consternation of the people who produce this, it's always called a Panama hat. Most people who see this hat would say, oh, it's a Panama hat. But it's actually produced in Ecuador. Okay? I will not show. Maybe you are. There you go. I will not show that. So let's, because the answer is there. So this is a hat. And it's a hat that is produced by traditional artisans in Ecuador from a place, from a certain place in Ecuador. And it's been practiced since the 16th century. Okay? And it's a painstaking process where they get the leaves of a toquilla, not tequila, a toquilla plant. And there's a process that by which they strip it and they weave it into a hat. And there's a process by which they pound it in order to shape it into the shape that it takes as a hat. Okay? Because of the process, which is very painstaking, takes a long time, it has no seams. It's very high quality. And mostly rich people, I think, really like this hat. And it's a status symbol for them to have this hat. Okay? So what IP tool was used here to protect this unique product? So let's launch the poll again. And again, 15 seconds for the participants to answer. Can I do it? Ayan. Good. Okay. There you go. Okay. So again, one of the things we should be thinking of here is whether our communities or the communities that we work with have these types of products, which handicrafts, that are done in a very traditional way that has been practiced by the community for a long time, no? And makes their product very unique and desirable in the market. Okay. So last 5 seconds. Okay, let's end the poll. Wow, it's a bit confusing, I guess, because the answers are all over the place. Someone said patent, someone said copyright, someone said trademark, someone said industrial designs, someone said trade secrets. However, the tool that was used in this instance was a geographical indication. So this is surprising because the common concept of a geographical indication, sorry, I'm speaking fast. The common concept of this geographical indication is that it is only agricultural products that can be protected. However, in some instances, they can protect the traditional practices of people from a certain area. Okay? So, as I said earlier, if you can think of some practices like this, they can actually be protected by geographical indications. Okay? The big advantage here is that it has no time limit. No? The protection is in perpetuity unless someone petitions for it to be canceled. Okay? This is not like the other protections, the trademark, 10 years only, but you can renew indefinitely. For geographical indications, no need to renew. Okay? So let's go to the last tool, the last example. Okay? This is familiar because I see many products of NTFP uses this fabric. Okay? So it's a fabric produced by the dream weavers here in the Philippines in Lake Sebu. Okay? They are called the dream weavers. because they produce the patterns from what they have dreamt, okay? And many of the patterns that, that come to them in their dreams have specific meanings, okay? So it can signal whether it's time for them to have children, it's time for them not to have children, okay? And many other things, okay? And this is something that they use to seek to protect their traditional knowledge, the traditional knowledge of their weavers. So what IP tool was used here? We have 15 seconds again so that we don't lose too much time. So someone asked from the last webinar how long it takes for this type of protection. And I asked the communities, and they said that it took them 3 years, from 2013 to 2016, to be able to gather all the weavers from Lake Sebu and to be able to codify their code of practice. And this is very important in order to make sure that the weaving produced is compliant with a certain standard. Okay, so there are 8 different weavers groups who are part of this, and this certification means that it was produced by the community, by a Tiboli weaver, and that it's up to the standards. Okay, so now let's end the poll. So that was confusing, huh? There are 2 correct answers here: geographical indication and collective trademark. Okay, because in the Philippines we do not have GI. Okay, so very good, thank you. Let's go to the next one. So that was the last one, as I said, and thank you very much for your answers. I hope we have understood to a certain extent the types of tools that were available and how they could be used to protect traditional knowledge. Okay, so let's move on and let's look at the summary. So to summarize now, there are different IP tools. If you notice, none of the examples that were presented were on this type of tool, which is a patent, okay? Although there are many examples of indigenous peoples using patents, it's not something that is preferred because there is a time limit to the protection, only 20 years, and it takes a lot of money in order to get a patent. So this is usually on medicinal plants, as well as plants that can be used to make a person beautiful, okay? Next, we have the copyright, and we talked about that earlier. A copyright protects the expression of an idea, but not the idea itself, okay? So books and paintings are included. And then most of the examples, as you noticed, were these trademarks, okay? Trademarks can be a collective trademark, and it can also be a certification mark. And this makes it preferred by indigenous peoples in protecting their TK and TCEs because it's renewable indefinitely. So there's no time limit to the protection, and it takes into consideration the traditional practices of indigenous peoples and local communities. So then we have geographical indications and industrial, well, I explained it earlier. Then we have industrial designs, which protects how a product looks rather than what it can do. And finally, trade secrets, which can be used by indigenous peoples, but it hasn't been used so much, okay? So that is to summarize our first webinar. And it went, sorry, Edna, it went beyond the 10 minutes that we promised, but I hope that it provides a good foundation for the rest of the webinar, the rest of the lecture. Okay. Okay. Sorry, I cannot see the questions.
The question.
Yes, the question is, can patents be renewed indefinitely? The answer is no. Once the patent protection period, 20 years, expires, then it goes to the public domain. That means that anyone can produce this product. of course, they can innovate and add something new to the product, but then that will extend the protection to another 20 years only. So there's a time limit, not renewable indefinitely. Okay. So now can we go to take a deeper look at traditional knowledge and traditional cultural expressions? Yes. Okay. I will assume that your answer is yes. Okay. So what is traditional knowledge? There you go. So it includes these things: know-how, the knowledge, the practices, the skills and innovations that results from ideas, no, from intellectual activity. And it is generated, it is created, maintained in a traditional context, okay? And it's passed from generation to generation. It may not be consecutive generations. It can skip a generation because sometimes it's the grandfather that would transfer medical knowledge to the grandson, maybe not to the son, but it's passed from one generation to another. And finally, the very important part, it's part of the tradition and the lifestyle of indigenous peoples and local communities. Okay, is it easy to understand? Maybe. Okay, so here are some examples. Skills include hunting skills, and I have here a picture of the Aita here in the Philippines, who have very unique and environment-friendly hunting skills. Can also include traditional medical knowledge, and this is an example from India, that is Ayurveda, okay, using different herbs to create medicines. And then you have here, what's this picture of? For those who have watched the Avengers Infinity Wars, this is the star of the last scene of the movie, okay, where you saw a sunset. This is a rice, the Ifugao rice terraces. And the traditional knowledge here is, if you see the top of the mountain, there is a cluster of trees that is called the Muyong system. And it is how they know to maintain the trees at the top of the mountain so that the terraces have water all throughout the year. Okay, so that is traditional knowledge. So it's the knowledge about how to do things in a good way, okay, that responds to the needs of the community. Okay, so maybe this there's no poll here, but maybe you just answer in your minds. Okay, are this traditional knowledge? So number one, the use of ayahuasca. It's a vine, this kind of vine, very nice, in the Western Amazon to prepare various medicines. Is it? You saw in the last slide that it is. No, it's similar to Ayurveda. So that's an example. Here, we have recipe of vegetable soup, which Emma's grandma told her. Is it traditional knowledge? Okay, let's see. If it's okay, I see the question, but I'll answer it later. Let's just finish the definition first. Okay, so is this traditional knowledge? Okay, for those who answered no, you are correct, because this is something passed by a grandmother to a grandchild, but it is not generated in a collective context. No, it's not created and maintained in a collective context. There's no community that is maintaining it. Okay, so last. There you go. The use of this cactus, and I didn't realize how beautiful this cactus is, no? It's used by hunters in Africa to suppress, or so that they don't get hungry right away, okay? So obviously this is traditional knowledge. Okay, so maybe this is a good time to answer the question. I have a question from Cambodia where we say one village, one product. Yes, OTOP. We also have that in the Philippines, I think. it can be protected by intellectual property if you put a brand on the product, okay? In itself, this program that is called One Village, One Product would be not intellectual property in itself, no? It becomes intellectual property if you put a label there that identifies it as a product of the community, no? That would be the intellectual property. And there are certain formalities that a person has to undergo in the country, which in short, you have to apply with the trademark office. Okay, there's an application form, there's an application fee, and there are certain technical requirements that have to be fulfilled so that you can get your trademark and so that it can become intellectual property. Okay, but in itself, maybe not. Okay, so there, this is traditional knowledge. Okay, we have more. Are there people from Thailand in the participants? Yeah, okay, I think so. So Plau Noi, I'm not sure if I'm pronouncing it correctly, forgive my pronunciation, but it is something used to treat ulcers. So correct me if I'm wrong. That's apparently how it looks. So obviously, is it traditional knowledge? Probably, because it's a community. Ah, okay. Is it traditional knowledge? Yeah, I can see a poll. So, okay, excellent. Yes, obviously it's traditional knowledge, yeah. So I have a question here, and it's asking about shifting cultivation. This is something practiced here in the Philippines also. And yes, it can be considered traditional knowledge because it's practiced by the community. Okay, and it's the community's experience that continues to improve certain processes related to shifting cultivation. Okay, so next, use of parts of the neem plant or neem tree to cure many ailments. This is an example from India. There, what the neem tree looks like. Yes, yes. Excellent. Okay, so everyone understands what traditional knowledge is. So it's obviously traditional knowledge, yeah? Okay, this is bedtime rituals. So rituals, can rituals be part of traditional knowledge? It's used by mothers in a community. Is that traditional knowledge? Maybe, maybe not. $50-50, yeah? Okay, let's end the poll. Bedtime rituals. Usually these rituals are individualized. Yeah, it depends on the mother, it depends on the child. It can be reading. So obviously it's not created by a community. It's not maintained by a community. So it's not. Okay, and finally, last one, production of a variety of rice called balatinao in some upland communities. Is that traditional knowledge? I forgot to put the picture. This picture, very nice. Very rich in fiber and also very low glycemic index. So it's good for diabetics. No, it doesn't have a lot of sugar. Do you think it is traditional knowledge? Yes. Okay, so let's end it. The answer is yes, and you're correct. It's traditional knowledge. Okay. Now, what is the difference between the knowledge and the expression? The knowledge is the idea, and the expression is the tangible thing by which the idea is expressed. Okay? So, traditional knowledge, you cannot touch or feel it because it's an idea, but the expression is something that you can touch. You can wear, maybe like this this garment, okay? So those are traditional cultural expressions. The forms in which TK is expressed, and it forms part of the identity of a community, okay? And passed down from generation to generation. Okay, so we have here, I'm not sure if any of you recognize this. This is in Cambodia. It's a community dance among the Bunong in Cambodia. Then you have this. I think I have several of these. It's a bag. And the bag is a product of the Karen in Thailand. And this very nice house, it's the expression of ideas from the Toraja in Sulawesi in Indonesia. Toraja house. Okay. Okay. I hope I was able to answer the question, except specific example for TK and its expressions. Okay, so these were the examples. And then as to the question on shifting cultivation, on whether it can be protected as an idea, with the current intellectual property system, there is no tool yet that is available to protect it. Okay, and unfortunately, in many countries, it is illegal, like in Thailand and the Philippines. Is that correct? Well, I can speak for the Philippines because the Philippines, it's definitely illegal. Okay. Now, let's go to the next. And these are the examples of TCEs. We have fire making. Okay. We have beer containers. That's from a tribe in Africa. We have the traditional dress, okay, in Timor. We have traditional dances in Sudan. Closer to home, we have these examples. Vietnam, that's a hat. Again, from Toraja, these are carvings, very nice. Again, the Bunong in Cambodia. And here, from Myanmar, dances. Okay. So, we have another poll, maybe to test if you are actually listening and understanding so far. So, the question here, okay, for the next poll is, which of the following is not a characteristic of traditional knowledge? Okay. Sige. Okay. 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 Maybe that ends the poll. And I have to say that understanding is getting better now. Most of you are correct. 14 out of 17. TK is not maintained by an individual. It's maintained by a group. Okay. So now, I would like to ask some of the participants if you have some examples of traditional knowledge. And if you do, you want to share it with the group, you can raise your hand. Okay? You can raise your hand using your, there's a way to raise the hand there. And our moderators, what do you call? Our moderators will activate your microphone. Okay. In the meantime, oh, I can see there's a question. How is TK related to the UNESCO Intangible Cultural Heritage? And thank you very much for the question. You are very much ahead of the pace of this lecture. Maybe we are getting impatient, but this is going to be covered in the next slides when we talk about the different types of protection. TK is also protected by UNESCO, but it's a different type of protection, and I will explain later what type of protection it is. Okay, so are there any participants who want to share examples of traditional knowledge or traditional cultural expressions in their communities? Okay.
Okay, let's have a 3 minutes discussion, 3 to 5 minutes discussion to make sure that before we go into the second part of the webinar, which is actually on protection measures, we have a very clear understanding of what is to be protected. So what is traditional knowledge and what is traditional cultural expression. So far, I think there are no questions and there are no further clarifications and no volunteer to give an example. Very good. So let's proceed. Oh, there's a question. Wait. You can also have a voice-in question if you don't want to use the chat box. We will open the microphone as soon as you raise your hand.
Hello.
And
Hi. Hello.
yes, we can hear you, P.
Okay. No, just sharing about can be off your YouTube. Just sharing about shifting cultivation that it was shared like there's no protection yet. And it's being practiced, it's not just only the certain group, but in different countries. But in Thailand, it was recognized as the part of the current culture. It's kind of like our part of our traditional way of life. So that is being recognized in the Ministry of Cultural. That is kind of the protection. But of course, like in like international level or other, still in the law is not recognize the shifting cultivation as the, how to say, they still see as the deforestation, but only the one ministry that recognize as the part of the culture of the current people. But of course, it's not only current people who practice shifting cultivation, there are other groups as well, like Lua people, or like Lisu or Aka, other group. But because of the policy and law, that's why they could not like really practice it. Yeah. Hello? I'm not sure. Is it okay?
Thank you, P, for sharing about shifting cultivation. You want to respond, G, or yes? Any more before we go to the response from our expert? There is another question? Or may we remind those who will be unmuted to turn down, lower down the volume of your microphone so we can receive you well. Okay, Jean, we respond to that and then we go now to what is protection and what are the measures to protect TK and TCE. Jean?
Okay, thank you. Yes, I am very familiar with shifting cultivation. Here we call it Sweden farming among my people. And one approach to protect it, I think, would be through what was mentioned earlier, the UNESCO Convention on Intangible Cultural Heritage. Of course, it will not be that easy to use this because there is a big stigma attached, which means people view it negatively because many people think that it has a very negative impact on the environment. Okay, so before we can get it protected, as an intangible cultural heritage, we still want, we have to get past this negative perception and convince those who are in charge of the registry of the UNESCO that this is not damaging to the environment. Okay, so I think we are ready to move to the next part. We have someone who raised the hand. Okay, yes, you can start talking now.
Can you introduce yourself?
Hello, Krajai. Hello, can you hear us? You may speak now and ask your question. Hello? Krajai? Or, okay.
Can you?
Yes, we can hear you now.
Okay, can you? Okay.
Yes.
Yes, my name is Krajai. I'm working with the EIPP and I'm from Bangladesh. I belong to Marma community in Bangladesh. So if we give an example like shifting cultivation in Bangladesh, it's kind of like an interest of a government. They're trying to forbidden that shifting cultivation in Chittagong Hill Tracts, though it's not like that much harmful for the environment, but still UNESCO and other like organizations who are really like to conserve our that traditional knowledge. I don't know how you think about this, whether it's really we should conserve for we should consider it as a traditional knowledge or what else? Yeah.
Okay. Well, definitely, it's based on the definition of traditional knowledge. It is indeed, shifting cultivation is indeed traditional knowledge because it fulfills all the criteria. Okay? So it can be protected, in fact. However, the question here is which tool we should use to protect it. Okay, so each of the tools I mentioned earlier would have certain requirements. Okay, and looking at shifting cultivation as traditional knowledge here, it seems that it would not fall under the intellectual property tools. However, it can be protected under other legal instruments. Okay, and maybe I would like now to invite also Edna to share some of her insights in relation to shifting cultivation.
Okay, thank you. With regards to shifting cultivation, yes, this is an issue by our communities. There is, if you look at the definition, in the Philippine context, if you look at the definition of community intellectual property rights, thank to IPRA, the Indigenous Peoples' Rights Act, there is actually a provision on community intellectual property rights. And that provision was defined in a legal measure that maybe later we will know, it's an example of a legal measure by a government on recognizing community intellectual property rights. What is particularly important to note about this definition in the Philippines is that it said community intellectual property rights are rights of the indigenous people to own, control, and develop in three broad areas. One is past, present, and future manifestation of their culture, with a long list of examples. Second is science and technology, including but not limited to human and other genetic resources, which includes resource management system, agricultural technologies. And the third one is community intellectual property rights on language, script, history, tradition, etc. So clearly, in our context here in the Philippines, there is a recognition that agricultural practices, and I think shifting cultivation falls squarely on that category, is a recognition that there is actually community intellectual property rights on this system. However, as Jing very well know it, the challenge is it is still in definition. There is no operational rules to actually guide the Philippine government and its offices and indigenous people how to actually do the actual protection. So, Jing?
Edna, you are very correct. Because here in the Philippines, before something can be implemented, there have to be implementing rules. And I suggest for countries where shifting cultivation is practiced, maybe we can also have a look at our laws so that we can determine our strategies for protecting our shifting cultivation. Here in the Philippines, we are trying to help the government to draft implementing rules so that we can already protect shifting cultivation as our traditional knowledge and with our community intellectual property rights. Okay, so I think we are very ready to move on with the discussion now because we are really talking about protection. So we're going now to look at the different options and the different types of protection. Okay, so just to review the earlier part, we have here certain products and what do these have in common? So we have here a traditional medicine in a bottle. We have here traditional carving. We have a beaded bag, which is a traditional design. And you already know this, the carpet, very famous carpet. Here is a Swiss watch, which I can tell you is protected by a geographical indication. So before it can be called a Swiss watch, at least 60% of the materials must have been produced in Switzerland, and at least 60% of the profits or the earnings must go to Switzerland before it can be called Swiss made. Okay. Then farming, agricultural practices, and then we have this Swiss knife. And obviously, all of these things are intellectual creations that people find beautiful or useful and worthy of protection. Okay? So how do we protect them? We said that the intellectual property system is an option. However, there are some gaps, okay, in using the intellectual property system. What are the gaps? This concept of the public domain. Earlier, someone asked about the time limit for protection of patents. And I said that this time limit is not renewable. After that protection, the knowledge, the invention goes to the public domain, which means that it's not protected. Okay? It's not protected because anyone can use it now. And if you remember the arrow I showed you at first, the balancing of interests, this is part of that concept of balancing of interests. You allow the inventor a limited time to exploit or to earn from the product, but after that time, you should allow everyone else to use it. That's the balance, okay? So that's one of the gaps. Of course, when we have our traditional knowledge, we do not want it going to the public domain. We don't want just anyone to use it without our guidance and our authorization, okay? Then the next one is this whole concept of copying versus inspiration. Because in copyright, people are allowed to be inspired by your original work. But how much inspiration does it take before it becomes a copy of your work? Okay. So here, and then we have offensive marks. Sometimes we allow people to use our traditional knowledge, but if they don't know the rules for how to use it, they can use it in an offensive way. Okay, and I'll show you some examples later. And finally, when innovations based on TK are created, the new product is protected, but under the current system, the underlying knowledge is not protected. And there's a danger that it goes to the public domain. Okay, so let's be concrete. You see the picture here? It's a model in, I think, New York. And there's something offensive here. I wonder if you can identify it. The offensive thing here is that she is using the headdress of a Canadian chief or an American chief from the tribes there. And this headdress is only given to those who are recognized leaders of the communities. So the way she is using it now is offensive to the communities because she did not do anything to earn the right to wear the headdress. Okay, so that's offensive use. Then the next, again, beauty contest. This is here in the Philippines. Beauty contestants, you know, have this part where they're supposed to wear national costumes. And here you can see that the skirt doesn't look like a skirt anymore because it's very small. So again, this is offensive use of certain traditional cultural expressions. And then you see here, this is from my people, actually, the weaving, the skirt. And again, it's used in a wrong way because the belt is supposed to be wrapping around the waist. She is using it to wrap around somewhere higher. And then finally, I'm not sure if you are familiar with this, Redskins. It's the name of a sports team in America. And the Indians there, the indigenous peoples there, they find it very offensive. Okay? So these are some of the gaps when we use the intellectual property system. And here are some key questions when we consider using the intellectual property system to protect our TK. Should the underlying knowledge be protected in the intellectual property sense? If so, what does protected? What does the word mean? Is it safeguarding? Is it preservation? Okay, I'll explain later what they mean. Should it be at the national level or should it be at the international level? And are there non-legal forms of protection that can be used to protect our knowledge more effectively? Okay, and we have here a diagram that shows that there are many different types of protection. Let's take first safeguarding. Safeguarding falls under this, UNESCO. And many of you were asking about UNESCO earlier. Under UNESCO, the concept of protection is to develop a registry where we can inscribe or put in the list our traditional knowledge that we want to protect. Okay? And when it's there, there are some incentives or some funding that can be given to those listed so that they can be further protected. Okay, so that's one. And this, in this model, when we say safeguarding, the mode of protection is to let people know, let everyone know that this is something here that is very important for our culture, and it allows many people to access and use or to go to the places, if it is a place, so that many more people can be aware of how important it or how beautiful it is. Okay. Preservation, one attempt at preservation falls under here, the Food and Agriculture Organization. People are starting to notice that many plants are becoming extinct, no? And so one of the approaches is to collect all the plants and put them in seed banks. So then we preserve these resources, okay? Then we have the others under human rights. Edna read out earlier this whole concept of community intellectual rights. And this comes from the human rights arena. It's part of the UN Declaration on the Rights of Indigenous Peoples. Then we have trade, which provides very strong protections. Geographical indications actually comes under the WTO, the World Trade Organization, okay? In the trade-related intellectual property rights, the TRIPS. And finally, we have intellectual property protection through WIPO, the World Intellectual Property Organization. So they are trying to develop international level protection. Okay? So, complicated. It's a bit complicated because when you say protection, sometimes it does not mean the same thing to everyone. Okay? So, some examples. One kind of protection is legal protection. That means you have a law. Okay? Another type of protection is you treat TK as intellectual property. That means that those who own the knowledge can control who uses it. Okay? And then you have using intellectual property principles to prevent unauthorized uses. Okay? And this is defensive, what we call defensive protection. You have ways to prevent other people from using the knowledge. And finally, this concept of sui generis protection. What does that mean? Even lawyers are confused. Sui generis means in a class of its own. Okay? In a class of its own. That means unique. It is not like others. There you go. So it means that you create laws. In fact, the Philippine law that Edna cited earlier, that's sui generis type of protection. It's different from the intellectual property system. Okay? So, someone is asking about how the General Agreement on Tariffs and Trade under the WTO operates in this scenario, and it is different from TRIPS. The GATT is a different agreement from the TRIPS agreement. However, when bilateral trade treaties are negotiated between countries, they usually include provisions on intellectual property. Okay, so they are related in a way. Although they are different instruments, the treaties will also cover intellectual property. Okay, so let's go to the next. How do we protect? When we decide how to protect, we have to think about certain things. No? What type of protection do we want? Do we want legal measures? When we say legal measures, it has to go through a process in our government. A law has to be enacted. Here in the Philippines, it took the Indigenous Peoples' Rights Act 20 years to be adopted. The National Land Use Act is more than 10 years. So it takes a long time when you think about legal measures. Then we have practical measures. Okay? These are non-legal, but they are changes into the practices of government agencies and other persons that result in the protection of our TK. So I'll show you later what that means. Okay? Do we want protection at the national level? Do we want something at the regional level, ASEAN or SAARC or South Asia? Because they're in Africa and in the Andean communities in Latin America, they have regional level laws on protection of traditional knowledge. Okay? Or do we want international level protection? So these are our options. So let's think through all of them. Okay. What is an example of a legal measure? Legal measure here, one of the legal measures is positive protection. That means you have a law that actively protects something, your TK. So one example is in New Zealand, very close here. It's part of Asia Pacific, no? And they have a Trademarks Act of 2002. Okay? Under this act, trademarks cannot be registered if they are offensive to their indigenous peoples, to the Maori. Okay? There is an advisory committee of Maori, of indigenous peoples, which advises on whether the mark is offensive or not. Okay? Some examples that they have of trademarks that they have deliberated on is this. It's for a beer, okay? Cody's Pale Ale. And then you have this Maori figure there, okay? And the advisory committee looked at it and tried to determine if it's offensive or not. And they said it's offensive, okay? Another is on cigarettes. Again, this cigarette has a Maori figure. So when the trademark was being applied for, the advisory committee examined it and they decided that both are offensive. So it was the registration of the trademark was denied. Okay, so this is a legal measure. It's part of national law. Another is in one of the islands, again, here in Asia Pacific, the Cook Islands. They have a Traditional Knowledge Act, very new, 2013. And it provides legal protection to traditional knowledge. This is one example of a sui generis national law to protect traditional knowledge. Okay? Key features, they define traditional knowledge, and it's the same as what I presented to you earlier. And it identifies who the rights of the right holders, no, what they can do. And they say that it's not possible to generate income or to use sacred knowledge. Okay, it's important for indigenous peoples. And there is a registration system. In order for the rights holders to have their rights, they have to register it. And then once you register, you can prevent others from using. Okay, so is it a good law? Okay, so any registered traditional knowledge cannot be used in a derogatory way, and it cannot be used without the permission of the rights holders. There is no time limit to the protection. Okay, and there are details on the registration process. And there are, as they say among lawyers, there is no crime if there is no punishment, no? So here, they define the punishment, so that means it's wrong. There is something wrong with stealing. So here, if somebody uses TK without permission of the local communities or the indigenous peoples, they can be sued and they can be fined up to 500,000 New Zealand dollars. Okay, and the works that were violating the rules can be destroyed or given back to the community. Okay, so that's an example of sui generis law. Another law in Peru is this regime for protection of collective knowledge. That's derived from biological resources, and this is usually medicinal plants. Okay, there. Requires prior informed consent. It allows license contracts, so other people can exploit if they have permission. And there's benefit sharing. Now, one of the important features here, because sometimes medicinal plants, like the example earlier, the neem plant, are used by the entire country, no? Everyone uses it. Here in the Philippines, we have lagundi, which is used all throughout the Philippines. I guess in Thailand, the plau noi, also used by many Thai people. Okay? So one innovation here in the law of Peru is there is a fund for development. So the benefits from the use of these resources goes to this fund, and it is used for development projects among indigenous peoples. Okay? Then there are registers, defines the role of the state, and it refers to the importance of customary law. Okay? This is how it looks. It's part of the intellectual property system. So you can see here industrial property, copyright, etc. And on an equal level, you see to the right, the sui generis protection. So it's the same level as the other types of intellectual property. And this is the name of the agency that protects. Okay? And there are many other laws. You can find them at the WIPO website. Okay? That's if you're interested. You can also find here, because from the last webinar, there were some who were not aware of the laws in their own countries. So me also, before I went to WIPO, I was not aware of the laws on protection of TK in my country. So I used this tool to look for the applicable laws. Okay, and you can use it also. So that was quite heavy. That's quite heavy discussion. And maybe I would like to ask if there are any questions at this point. Questions? Okay, no questions. Can we proceed? Okay, there are no questions. We proceed to the next type of protection. So we're finished with positive protection using legal measures. So these are usually laws, okay? Now we have defensive protection. What does defensive protection mean? It means you have mechanisms that prevent others from using your knowledge. You remember the examples earlier, the neem tree and the plaunoy. They were patented by others. In the case of plaunoy, it was patented by the Japanese. In the case of neem, the Americans attempted to patent it as a, I think, toothpaste. Okay. Now, because of this defensive protection, this one that was in place, it's called the Indian Traditional Knowledge Digital Library. They were able to show that there were already documents that showed that Indians traditionally use the neem plant for many different things, including what the person was applying for a patent on. Okay, so here you document it. The objective is to prevent misappropriation, and it's in different languages so that others can use it. And they scanned all the published material on use of their traditional medicines in Ayurveda, Unani, Siddha, and Yoga. Okay, those were in local languages, but they translated into the main languages, such as English, Spanish, German, and Japanese. Okay, that's because these are the mostly where the countries patent different plants. Okay, and only the patent offices can access it so as to prevent biopiracy. And it's for searching and examination only. Okay, so there, that's the logo of the TKDL, that's yoga, and that's Unani. It's also the use of medicinal plants. Okay, so that's one example. And it has been used many times by the Indians to prevent others from getting patents over their traditional medicines. Okay, indigenous peoples have also been encouraged to document their traditional knowledge so that others, it's evidence, no, that they have already been using it, so that others cannot claim that they were the ones who invented the uses of your traditional knowledge. Okay. Next is the National Commission on Against Biopiracy in Peru. And this is, they don't document, but they look at all those patent applications to see whether plants from Peru are being applied for in other countries. Okay? That's what we call biopiracy, when others use your genetic resources without permission. Okay? The main functions: provide protection, identify patent applications that include traditional knowledge from Peru, and etc. Okay? So what are examples? So they object when they see that there's a patent application on plants from Peru. They challenge it. They object to the registration. So examples are these. So there's maca, yakon, etc. So they look at the patent applications. They look at the names of the plants. If some are from Peru, they go to the patent office and they object to the registration. Okay. So those are the defensive protection. Okay. It's like a shield to prevent others from using your knowledge. Okay. The next are practical measures. There are many. Okay. Maybe at this point, are there questions? Are there any questions? Because it's a little bit complicated, no? So if anyone wants to clarify some things, then this is your chance. Okay, there are no questions. Let's proceed. Practical measures. So some practical measures, the characteristic of practical measures is that they don't require a long time for the government to adopt or to legislate it, okay? Because these are measures that are not legal in nature, but they guide the practices of some institutions. Example, the British Library archival sound recordings, okay? They have recordings of many different sounds, including some indigenous chants, indigenous songs, and indigenous languages, okay? And they wanted some guidance on how to protect the sounds that are in their archives. So they asked WIPO for help to guide them on ethical and permitted use of the recordings, okay? And this is what they came up with. There are two key passages. Since it's very small, let's reproduce it here. It says, the recordings should not be altered in ways that might be derogatory or offensive to the indigenous communities who own that sound. Then it says that while the British Library may be the owner of the intellectual property of the digitized version of the recordings, they recognize that the rights, the traditional knowledge holders still retain other rights. Therefore, prior informed consent is required from the library as well as from the TK owners for the use, the commercial use of the materials, okay? So this is not a law, it's a rule by the library, but it ends up protecting traditional knowledge, okay? And then we have guides, best practice guides. Here in the Philippines, we really love festivals, no? Some people, they schedule their vacations according to the festivals here in the Philippines. And I'm sure many others, Loy Kratung, I guess I can imagine in Thailand, and other festivals that are actually indigenous in origin. And the problem sometimes here is that we show off our traditional knowledge, our traditional cultural expressions, no? Our traditional dress, our traditional dances, traditional songs, etc. And at the festivals, there are many people who have cameras and recorders, no? The cell phone nowadays can be a camera, can also be a video, yeah? And so this best practice guides provides guidance for some people, for the people attending the festival, so that they do not violate the rights of the TK holders, the owners of the TCEs. Okay? So there, those are the strategies in the guides. Respect. They prepare signs, notices, and warnings. So no videotaping, no taking of pictures, if that's what they want, yeah? And then they look at maybe Facebook, other websites, to see whether recordings of the festivals were stolen, no? Used without authorization, okay? And they advise that these signs should appear at different areas, and provides options to, prevent filming or allow some filming, but for personal use only of the people who are videotaping. Okay, so that's a best practice guide. That's the example. Finally, no, this is not the final, but this is community protocols. Okay, and perhaps this might be the most relevant for indigenous people because it doesn't require a very long process to adopt a law, and it doesn't require talking to different establishments for them to have a policy to protect the traditional knowledge and expressions of indigenous peoples. So what is a community protocol? It decides the rules. The community writes down the rules for how other people can access and use their traditional knowledge. And it's good because the communities determine their own rules, usually based on customary law. Obviously, no one size fits all because each community is unique and the protocol can be dynamic. It can change through time. Okay. And maybe, for example, I'd like to call on Edna to provide one example, because here we have an example from Australia, but maybe we want something closer to home, to Asia. Okay, Edna, please.
Thank you, Jean. Okay. And share screen. Thank you, Jean. So for the Philippines experience, it's actually a mix of community protocols as well as best practices guide. I'm not sure if this would fall squarely under community protocols, under what you discussed under an intellectual property tools, because if you look at the definition of community protocol, it's actually to regulate third-party access to a particular resource. But let me share to you, and I will share my screen. For this good practice, it's a good practice manual. We call it Community Protocols on Forest Honey Harvesting and Processing. It is for limited circulation because while it is really for harvesting and processing, it is based on the Indigenous Knowledge System and Practices, IKSP, of Indigenous people, first from Palawan, and it was developed with the help of NTFP. In the Philippines, you know, the TK, the traditional knowledge and traditional cultural expression, we lump it to one word, which we call IKSP. Okay, IKSP, Indigenous Knowledge Systems and Practices. Sorry. Let me share my screen to just give you a snapshot of an example of our honey harvesting and processing protocol. So it was published in various languages, dialects, and the improvement, share screen, let me, who can share? Only host, all panelists. Okay. So we're having some technical difficulty to share my screen, but let me continue. So it is a combination of IKSP because it was developed by indigenous community sorry, so I have an actual indigenous community in Palawan and in Mindoro. And this was eventually, of course, adopted the Philippine Forest Honey Network, which their mark as a collective mark you saw earlier in the example of trademarks. What is particularly striking about this is that the technical assistance of NTFP was, of course, in coming up with the good manufacturing practices. This is actually one for food, where it's a system for ensuring that products are consistently produced and controlled according to quality standards. Because when indigenous people wanted to break into markets, they wanted to make sure their enterprise products are actually of good quality at par, but at the same time protecting indigenous knowledge system, then this should all be considered. It is we consider as a community protocol. We have not, yet discussed that it should be protected by itself, but at itself, if you look at the Indian example, if one would try to claim this particular harvesting and processing of forest honey, then there is already a documentation that there is an existing community protocol. So from community protocol, if these practices are actually acknowledged by a local ordinance and a provincial ordinance, and then this can fall into one of defensive measures, right? So because it's not really that costly, it is really IP owned and IP led. development of protocols. So what do you think about this, or expert? Are we on the same track? And what are possible strategies to further make sure there is actual protection in these community protocols?
Okay. I think that's a very important first step towards protection of the practice of honey collection. No? As a matter of fact, the document can serve two purposes. One is preparation for protection of the practice as a collective trademark or a geographical indication, because it specifies standards for sustainable collection of honey, no? And another, it can provide, as Edna said, defensive protection. And it also, in order to improve it, my only suggestion here, because now it has defensive protection and it can prepare for intellectual property protection. The third, which I would like to suggest, is for it to contain rules on access rules. No? What if other people want to access, or what if other people want to use some parts of their traditional knowledge? What are the rules that should be followed? Okay, so I think that's very useful, and definitely yes. And now, yes. So we have some questions. Okay. We have one question here. Village common forest roles or rules, is it a community protocol? Yes, it can be a community protocol because it identifies here the rules for, managing traditional management of the forest. Yeah. But also, if it contains rules on how other people can use products from the forest, then it can be a community protocol in the protection sense, no? In the sense that we are using here, okay? As for, okay. Based on practical experiences of ASEAN, are there any applicable method that could be combined as common guidelines? So this is another question here. And my response here, obviously at present, there is nothing. But I think based on how many countries in Southeast Asia have ratified or acceded to the, what do you call this, the Nagoya Protocol on Access and Benefit Sharing, I think there is common ground. There are a few countries who have not yet ratified, but once we ratify this international treaty, this protocol, then everyone, all countries here in ASEAN would be required to develop laws, national laws, that comply with the protocol. And then we would have something common ground to have a regional level protection. So not yet, but I think we are very close. Okay, so this is something that we can strive for. Okay, may I ask some other the other participants if you have examples of these protocols within your areas, within your communities, and if anyone would like to share. Wala?
So I have a question, G.
Yes.
So in some countries, for example, a specific example is Indonesia. So there is the certification system, the PGS.
Mm-hmm.
So I don't know how is it treated under the intellectual property tools, but there is that participatory guarantee system that they also have their marks. In Indonesia's case, they have rattan. Let me flash the picture of this mark that the particular rattan is sustainably harvested and has undergone the participatory guarantee system. How how is PGS and
Yes.
their product marks
Yes.
considered under the intellectual property
Yes.
rights
Yes.
system?
It can be a certification mark. As we studied earlier, there were many examples of certification mark, and it certifies that the product is produced in accordance with a certain standard. Okay. However, I'm not sure if those certifications were under the intellectual property system, because there are some certification schemes, Forest Stewardship Council, for example. Here in the Philippines, organic, OOCP, organic certification. They are not within the intellectual property system, but they are separate. They are separate certification systems. So they qualify certainly to be protected under the intellectual property system, but sometimes they are separate. And they're also useful, for protecting our products, traditional knowledge-based products.
Thank you, Jean.
Yes.
So I think we are running out of time, so we have to go to the international protection and then have a quick Q&A after we wrap up.
Okay. Okay. So, okay. So, now let's go through the last few slides of the presentation. Okay. And as I said earlier, we also have, in addition to what was the first, we had positive protection. Then we had sui generis, no? Then we had defensive protection. And then we had non-legal measures, which are guides, and community protocols. And now we have attempt to provide international level protection. Okay. This attempt is being carried out at the World Intellectual Property Organization, WIPO. Okay. They have an Inter-Governmental Committee to look at issues on traditional knowledge and intellectual property. Okay. It was formed in 2000, the year 2000, after 3 years of fact-finding missions. Because in 1997, the global issues sector at WIPO noticed that the needs of traditional knowledge holders are not being met. Okay, so they studied, they went to many different countries, and they talked to traditional knowledge holders, and they documented the situation and what they needed from the intellectual property system. So in 2000, they created the committee, and yes, the committee is 18 years old now. Your math is correct. And it's a forum where negotiations take place to develop international instruments. And it brings together the members of WIPO, these are governments. Indigenous peoples are welcome to participate here. But businesses, civil society, and other NGOs are also there. Okay? And it's a place where dialogue could take place between scientists and traditional knowledge holders. So, although it's taking them a long, long time to come up with an international treaty to protect traditional knowledge, there have been some steps forward in terms of developing certain rules or non-legal or sui generis types of protection for traditional knowledge. Okay? The current draft contains the following. It requires consent of the knowledge owners before the knowledge can be used. It recognizes the collective rights of indigenous peoples. There's no time limit to the protection. Recognizes that customary law is going to guide the rules for access and use. And it requires those who are applying for patents to disclose where they got the knowledge that led to their invention. If they say that it's indigenous peoples who gave them the knowledge, they have to provide evidence that there is consent and that they are sharing the benefits, that they are going to share the benefits. Okay, so this is like the Nagoya Protocol. So that's the last slide actually in terms of the presentation. And it, as I said, it deals with the international level protection. And the short answer is there is none. There is no international legal protection yet, but we're trying to get there. Okay. So that's the end of the question. The next slide is actually a homework. And it just basically says that we will send you some case studies with questions, and the answers will be discussed at the next webinar. Okay. So with that, thank you very much. Okay. And I hope this was helpful. And I look forward to any questions or clarifications from the participants. Thank you. Ano mag-stop ng share?
Doon na lang sa HIVE. Okay. Thank you very much, Jing. Thank you very much, Jing. We still have a few minutes before 4 o'clock, and I hope everybody is still tuned in and still very much interested to the last stretch of our webinar. There was a question here from Chrissy. I think along the way, this was not pasted, is that among a number of these intellectual property tools that we discussed, is there a hierarchy of tools in terms of providing more protection, or is it unique, or how do you treat it? Hierarchy.
Yes, of course. The strongest protection would be if we had some laws. However, even without laws in place, one very strong protection that we could have is for indigenous communities to have community protocols. And note, this is not just for indigenous peoples, it's also for local communities. Okay? So if we have community protocols, this can get recognized in other forums. It would be the basis, because this is a set of rules that reflects customary law. Okay? And under many international agreements, in fact, even national laws, they recognize the rules at the local level. Okay? So apart from national laws, one very key protection would be having community protocols. Then finally, international system would be crucial, because it would, as you know, many of the stolen traditional knowledge happen across borders, no? The Plaunoy was stolen, misappropriated by Japanese scientists, and they had it patented there. The neem was attempted to be stolen by Americans. So having an international system would also be important to prevent these types of things from happening. Okay? Because if it's only local, sometimes it's tricky how to get other countries to recognize your national rules. Okay? So there's no... yes.
Thank you, Jing. As a follow-up questions, so you discussed again the hierarchy in terms of the legal protection measures. The second question is, among the intellectual property tools, trademarks, patents, copyrights, geographical indicators, which, in terms of hierarchy, so what can we use if we are protecting some products or traditional cultural expression? We have to also delineate the two, right? When we are using intellectual property rights tool, this is the mainstream system that we are availing to protect our TK and TCE. But aside from the mainstream existing tools, there is a menu of practical measures, such as community protocols, that we can also use, and we can also not only use, but we can also advocate and promote, so this protection would in turn be noticed by authorities and governments, and they would give in a defensive protection or a positive protection through laws, rules, measures, and even resolution, recognizing that. So let's answer first the hierarchy of IP tools.
Well, in terms of the hierarchy of IP tools, for the mainstream, which means non-indigenous, they would regard patents as the highest form of protection, no? But for indigenous peoples, in deciding what is the strongest form of protection for us, we have many things to take into consideration. One is whether it takes our customary practices into account, and the second, if it limits the time scope of our protection over our traditional knowledge. And with those two key concerns, taking it into consideration, I would say that maybe the strongest would be probably geographical indications, okay? Because it recognizes traditional ways of doing this. Of course, we have to have a product, no? We have to have a product that the market wants. Then it's strong because there's no time limit. Yeah, there's no need to renew. We don't need to pay renewal fees every 10 years. So in short, it's the most practical, maybe not the strongest, but the most practical for indigenous peoples. Then we go trademarks because of the time limit. Maybe the other tools have been used to varying degrees. And I think it would depend on the needs and the expectations of particular communities. To be honest, I cannot speak for most communities, no, for all communities, because they will have to decide which are the preferred protections based on what they need and what they require. Yes.
Okay. Thank you, Jean. Yes, and it could be in the different products, Jean. Like, for example, my question is, for NTFP, we have a lot of weaving. We have a lot of products from forest foods. We also have products, natural dye. So we can also use patent. We opt to use that because of the process. But as of now, we are still very new into the intellectual property rights and availing of this. So trademarks in an easy one, but of course it's not ideal. However, we are also looking into the community protocols. There is a text question again. Thank you, Chrissy. Asking us if we can give more example of community protocols, not necessarily today. And this is a good segue for our third and last webinar, because our third and last webinar on June will focus specifically on community protocols and practical approaches. We will discuss a number of very good examples and maybe also not very good example that we can critique. And after the webinar, you will have a working knowledge and how actually to facilitate and even actually innovate on community protocols. I hope that satisfies satisfies Chrissy. Krishna, so another question. Wants to share? Yes, we have 1 minute left, but go, Krishna.
Can you hear me?
Yes.
Yeah.
Krishna from India, yes.
Hi, everyone. This is Krishna from India. Can you all hear me?
Yes, we can hear you. Go ahead,
okay,
please.
So the comment is based on some of the experience which I have had in working. This is regarding documentation of traditional knowledge, etc. What Jenny shared about TKDL and the Ayurveda, Unani, Siddha systems being documented and all. These knowledge systems are not necessarily indigenous people's knowledge systems. They are more mainstream knowledge systems. So, so when it comes to indigenous people's knowledge system, we have a sui generis law in the country, but the documentation is a little problematic because the entire control of the documentation is centralized, and the central authority has the right to give access to people who want to exploit the bioresources or the traditional knowledge associated with it. So that is something which is quite challenging in terms of how to address it, what to do, how to protect the indigenous people's knowledge systems and their bioresources, even by using documentation, but also protecting it so that it is not available, available through a central authority in the government. So that was just a comment or an experience which I wanted to share.
Yeah, thank you very much for the experience you shared. Indeed, there are many challenges also with documentation, because sometimes it ends up being a source or being a facilitator of biopiracy. So we have to be very careful when we decide to document. We have to be conscious of how to protect the information in the documentation. Okay. I have a question here from P. Do you have any evidence or examples on the compensation or remedy or good protection for IPLC? The examples that I came across while I was at WIPO are, well, some good examples. One is in Canada. One big problem in Canada is diabetes. And one tribe has traditional plants, plants that they traditionally use for lowering blood sugar levels. And so they approached a university, and the university agreed to move forward with the scientific study of the properties of those plants. And it's a partnership between the community and the university. They haven't developed the drug yet because normally it takes a long time. But what happened is that there is an agreement for compensation there. And when the drug is finally produced, it will be co-owned by the community and by the university. Okay? The benefits are monetary and also non-monetary. There were already non-monetary benefits that were given, even if there is no product yet that has been developed. So they have assisted the community in many ways. So that's one example. Another example probably is maybe here in the Philippines. There is a tribe, an Aita tribe in central Luzon. And the University of the Philippines wanted to study properties of some animals within the territory of the Aita. And they entered into an agreement. They conducted a consent process with the community, and they have an agreement, and there are benefits, that, again, monetary and non-monetary that were given to the community. So those are two examples that I can think of. Maybe Edna can share if we have time.
Next time we will have time.
Okay. Yeah, we can share some more at the next webinar. But if you notice, most of these examples are good examples because the rights of the communities are recognized and respected. And sometimes the communities themselves decide, to approach an institution, and therefore, because they approach, they are able to assert that their rights be respected in any agreement.
Okay.
Okay, thank you very much, Jean. So this wraps up our webinar, the second webinar. And I invite you to register for the third webinar, which will be more exciting. It's now on practical tools. We will also send you the presentation of this webinar, and also in the next few weeks, the recording of this webinar. So thank you very much. Before I end, I would like to thank Jing, of course, the HIVE team, Liana, Dazzle, and Earl, and of course, Ruth, NTFP Philippines, for hosting us in their much cooler office. Thank you very much, and see you in the next webinar.